So my clock shows that it is now, I guess it would be 11 o'clock a.m. Eastern, so because it's 10 a.m. here. So I see you started the recording, Bobby. The first thing that I have on my agenda here is that, I don't know if you want to go ahead and take roll call.
Yes, I'll go ahead and do that now. I've seen people trickling in, so I have some notes already, but we just want to make sure that everyone's audio and video is working. So when you hear your name, just let us know you can hear us and that we can hear you by saying yes or present or something. Boris Burstein, Susan Braden, Betty Jo Christian, John Duffy, Don Elliott, I saw you.
Here.
We can hear you. Aaron Hawley, Paul Kamenar, Ron Levin.
I'm here, but only for a half hour. Then I go to class and I'll be back after class if you're still here.
We're happy to have you.
We're happy that you're joining us for as much as you can, Ron.
Elbert Lynn, Mary McQueen, David Michaels, Stephanie Middleton, Jeff Menier, Alan Morrison, Judge Randolph Moss, Victoria Norse, Leah Otis, Deborah Perlin, Judge Plager, Judge Rommel, Eugene Scalia, David Shanka, I saw John Siegel, Stephanie Tatham, Drita Tanuzzi, David Trissell, Andrew Volmer.
Here.
You. All right, we can hear you. Cheryl Walter, Kenny Wright, and
Here.
Allison Zeef. Perfect.
And Bobby, I see a few people that you called early in the roll
Yeah.
have joined us since then. So I don't know if we want to check the mics. I know particularly Professor Duffy had submitted comments, so we ought to make sure his microphone is working.
Yeah, Paul Kamen, our senior fellow here by phone.
Perfect. We
Excellent.
can hear
Thank
you
you,
as well.
Paul.
Yeah.
John Duffy.
Boris Burstein, John Duffy. Yeah.
Yes,
Okay.
can you hear me?
I heard you, John. Yeah.
Yep. Boris is here.
All right. Perfect. Thank
And
you.
we
And I
have
can
a
hear
couple
you as
of
well.
other people by phone. Can we discern who those people are? If they're members or senior fellows or, government, whether they're public members or government members, or senior fellows, if you're joining in by phone, please let us know who you are. Okay.
Bobby, you didn't
Jennifer.
call my name, but Richard Pierce, I'm also here.
Excellent. Good to
I
see
have
you,
you
Dan.
down. Perfect. And we can hear you. And the other,
Yeah, this is Ed Banks from the Department of Justice.
all right, perfect, Mr. Banks.
Wonderful.
Bobby, this
Thank you
is
so
Mike Binger from the National Center for State Courts. I'm standing in for Mary McQueen.
Terrific. Thank you. I can hear you as well. And is Professor Funk on the line as well? I do see him logging in, but we'll make sure his microphone is working once he's logged in. All right, that should be it. Professor Funk, did you make it in? And I see Steph Tatham as well. Okay, Professor Hickman, I think we're in a pretty good spot. We can try and handle the phones on the back end.
Okay. Well, we will work with it as best we can. We simply ask that everybody be patient as we navigate the technology. Please do, though, if you find yourself experiencing technical difficulties during the meeting, if you could reach out using the chat function or alternatively using email. The ACUS staff are always happy to help you out with any troubleshooting or moving to alternative means of participating in the meeting if you're having technical difficulties. So with that, I'd like to turn the microphone over to our Vice Chair and Executive Director, Matt Weiner, for his opening remarks. Matt, you're still muted.
thanks, Kristen, and thanks everyone for participating. This is very robust participation, which is very encouraging and bodes well for the eventual recommendation. I just have 3 comments. One, I'd like to just thank John Siegel, especially for giving so much of his time over. I don't even want to say the last few months, but maybe the last year and a half to this project. We very much appreciate it, and I don't think anybody could do this as well as there's certainly no more suitable consultant than John Siegel for this project. So thank you very much, John. I'd also like to thank those of you who submitted comments in advance on the draft on the draft I guess list. It is at this point, we don't have a recommendation, especially John Duffy, who has real expertise in our subject. I know others have submitted comments to John on the draft source book, and I'm confident that they will be appropriately thanked and acknowledged in the source book once it's published. Second comment, while John's list of issues is certainly going to structure the discussion for the committee meetings, the committee is not confined to that list. If committee members have identify other problems, infirmities, and so forth in statutory provisions, they should certainly raise them, at an appropriate time, as Kristen indicates. Finally, the third issue is the matter of the title. We've gotten some suggestions for alternatives to the title. Our normal way of doing things is to allow the committee to ultimately, when it adopts a recommendation, to propose a new title. The new title then gets voted on by the assembly at the plenary session. We don't normally change the project name during the until the committee has, until the assembly has actually adopted a new title. In this case, though, we are open to changing the name of the project if there's a consensus on the committee. And I leave it to Kristen to decide when the subject of the title should be discussed. I certainly wouldn't want, and I suspect Kristen doesn't want either, doesn't want us to spend an inordinate amount of time debating the title rather than the substance of the recommendation. When the issue of the title comes up, or the name of the project comes up, I may have a few additional comments. But with that, let me turn it back over to Kristen. I know this is we have a lot to do today, and I don't want to take up any more of the committee's time. Thanks, Kristen.
Sure, thank you, Matt. And we will return to the subject of the title shortly. Before we do that, though, I feel the need to go through, since we're on, yet another platform, just a reminder for everyone with respect to the protocols for our discussion. So ACUS members, of course, have full speaking privileges and are able to unmute yourselves. To avoid background noise, though, I would very much appreciate it if you could keep your microphone on mute and either physically raise your hand or add a comment in the chat feature if you'd like to speak. And by physically raising your hand, I will say, because we have so many people who are here, I can't see everybody on the view screen. Especially once we start sharing the recommendations, the draft of them the way we usually do, I'm not going to be able to see people's pictures physically. So, I think the best way to go about this, if everyone will look at the bottom of this, somewhere on your screen, for me, it's at the bottom of the screen, there's a little button that says reactions. And if you click on that button, then there is a raise hand feature. And so if you raise your hand in Zoom using that raise hand feature, it shows up as a little yellow hand to the right, and I can keep track of people that way. Or you are, of course, also welcome to signal me in the chat that you have something that you would like to say and that you would like to get into the queue. These are all different ways that we can go about signaling that we want to speak, and I'm happy to entertain all of them. Again, just begging your patience as we try our best to get through everyone who would like to speak. But once as we're going through the queue, once I have an indication that you would like to speak, I would call on you and you can unmute yourself. Then please remute yourself when you're done speaking. I'd also like to ask people who are speaking, if possible, to use the webcam, so that we can see you when you are speaking. I think that we'd all appreciate that. On the other hand, I also recognize that some people don't have the most stable Wi-Fi situations, and so the video may be challenging for some people. Again, we're all just going to do the best that we can. Please note that although we welcome the participation of people who are not ACUS members or alternates, ACUS members are to be given priority in speaking, which includes Judicial Review Committee members, including government members or their designated alternates, public members, senior fellows, liaison representatives, and special counsels. If we have time at the end of the meeting, then I will turn to members of the general public and recognize you at that point in time. If you are unsure of your status, then Bobby and I both have lists of committee members and ACUS participants. And so if you're unsure of your status, you might let us know in the chat and we can resolve that for you. For members of the public, please use the chat feature to indicate if you'd like to speak. Again, I will turn to members of the general public at the end of the meeting if we have time. But if you will let us know if you'd like to speak by signaling as much in the chat area, then when we get to that point of the meeting, I will turn to you and the person running the meeting will unmute you at that time. And she will then mute you again when you are done speaking. Again, for all participants, I'd like for you to use the chat function to indicate you'd like to speak, but at the same time, also you can use the raised yellow hand, which is another way of signaling me. Either of those will work. But when it comes to actually providing the substance of your remarks, please only use the chat function to indicate that you're interested in speaking and not for any sort of sidebar discussions or substantive comments. Holding sidebar discussions or putting substantive comments into the chat feature becomes very confusing as we try to conduct this meeting in an orderly fashion. So if you could just use the chat feature to signal to us if you want to speak, or if you're having technical difficulties or need to confirm your status, those sorts of logistical details, as opposed to the making substantive comments, we would very much appreciate it. Okay, if we have any issues that come to a vote, please remember that only members of the Judicial Review Committee are eligible to vote. That does include at this stage, again, government members and their designated alternatives, public members of the committee, senior fellows, liaison representatives, and special counsels. Again, if you're not sure of your status, Bobby and I both have a list of committee members, and you can ask us in the chat whether you are eligible to vote. In any event, any questions at this point regarding those logistics, please, you can let us know in the chat. Otherwise, what I'd like to do at this point in the meeting is turn it over to Professor John Siegel to introduce our project and provide us with an overview of the recommendations that we will be discussing today. Professor Siegel, please.
Thank you, Kristen, and thank you, Matt, for your earlier very generous remarks. So those of you who are on the committee will recall that we've actually had two previous presentations on this project that I gave. First, we had a meeting of this committee about 3 months ago, in which I gave an overview relative to the recommendations growing out of this project. And then if you were at the last plenary session of the Assembly, I spoke for 10 or 15 minutes at that plenary session about the source book end of the project. So, I mean, unless there's a specific request, I don't think it's necessary for me to go over the whole background of the project again. So I'll just in like 1 minute remind everyone that the essence of this project is that we wanted to prepare a compilation and analysis of all the provisions in the United States Code providing for judicial review of agency action. So with the help of a lot of work from the staff, we compiled all the statutory provisions that do that. And then my task was to read all of them and say something interesting. And that's what the source book part of the project is. And then along the way, you can't read 600 plus statutes without noticing some areas where improvement might be possible. So I compiled, as I was going along, some potential recommendations, and that's what's before this committee. So as I said, I've presented that previously. So since that previous meeting we had here about 3 months ago, I've been working on finishing the source book. So the draft was circulated to the Board of Advisors of that project, and I got some comments from members of the Board of Advisors and some comments from the staff. And I want to thank everyone who gave comments, but I particularly want to single out Professor Ron Levin, who gave several pages of detailed, very useful, very good comments that I'm still finishing up. I was hoping to have that finished in time for today's meeting. I'm sorry I wasn't able to meet that. It's been a very busy period. But it will be done before the next meeting because according to my contract, it's due April 15th. So it will be completely done 2 weeks from today. And then you'll have it there. The other thing I wanted to mention in terms of what's happened since we last met is I conducted some very useful interviews with some people on the Capitol Hill about this project, some people on the House side and some people on the Senate side, to whom I showed the draft report again as it existed when it was circulated to the Board of Advisors. And I had a very interesting conversation with people on both sides. And the one thing I will specifically call to everyone's attention is they all thought that one of the most useful parts of the project would be the checklist that appears at the end of the draft source book. I don't know if people have had time to read the draft source book, but at the end of the draft source book, there is this checklist for Congress. Because one of the things that came out in the interviews was that, people on the Hill who are actually in charge of drafting these statutes are not necessarily that expert in some of the things they might need to know to draft the statutes well. And, many of them are, these things are drafted in a hurry and they're just copying from statutes that already exist. So that checklist, questions like, is it bad to use a certain form of words to set the time limit? One of the first things in the recommendation list before us, they had no idea that was an issue, and various other things that are in the checklist and that seem very obvious to some of the people on this committee who have a great deal of experience and expertise in judicial review of agency action. Some of the people drafting these statutes just really have no idea that some of the things they might say could set up issues and could create problems. So they all said that checklist at the end is going to be very useful. So if I might suggest, in addition to the work that we're going to do today and at the next meeting, if anybody would care to look at the checklist at the end of the source book and send me any suggestions that they have with regard to that, those would be very welcome, and I'd be happy to incorporate them. But please do that soon, because as I said, that's due in a couple of weeks. All right. So the recommendations that are before the committee today are the ones that, let me say, survived the discussion that we had at the previous meeting, the sort of pre-meeting on this project. You may recall, I have, as you may have seen in the source book, there are a couple of slightly more ambitious recommendations that people thought would better be left for some other project. So those aren't before us today. But the ones that we do have, you can see on page 2 of the memo from our attorney advisor, Bobby Ochoa. We have good and bad ways to specify the time within which to seek judicial review, and particularly avoiding setting it up so that people have one day less than they might think if you would set things up the usual way. There's a recommendation about saying what is the action that starts the time. That should be clearly specified. And I know, I'll just say Ron Levin had a comment on this because I know he has to leave soon. I said if the event is the promulgation of a regulation, it should start from the date the regulation is published in the Federal Register. And Ron pointed out, do we need to make clear what date that is? And I agree. I talked to the Federal Register's ACUS member, and she agreed it should be the date of the issue in which the regulation appears. So there's a date on each issue of the Federal Register, and that should be the date. The recommendation that if Congress says you can seek judicial review in a particular court, Congress should say universally that court shall have jurisdiction to hear the resulting case. Seems very obvious, but if that court is a court of appeals, it might not have such jurisdiction. One about the document, well, two actually about the document used to initiate review. One that notices of appeal should be treated as petitions for review where necessary and vice versa. Professor Duffy suggested that we encourage Congress to use the phraseology of petition for review and avoid notice of appeal. And I agree with that, and I'd be happy to incorporate it, although that hasn't been changed in the draft that you have before you. That Congress should not specify the required content of the petition for review. There are some statutes that do that, as I discussed at the last meeting. That just ends up causing trouble. That should be avoided. A recommendation about the race to the courthouse. As I mentioned, this was a very successful ACUS recommendation from the 1980s, but there's this little quirk in the way it happened to get written up so that you're only eligible to participate in the race to the courthouse if you send notice of the filing to the agency, whereas some statutes say the agency shall be notified by the clerk. And I suggested amending it so that those would trigger the race to the courthouse provisions just as well as one that come from parties. And finally, this one about statutes that require that when you seek review, you simultaneously file the document with the agency. I said that should be sufficient if it's done with reasonable promptness. And again, this was another good suggestion by Professor Duffy, which I'd be happy to incorporate. That there be something more specific than just the phrase reasonable promptness. So those are the ones we have before us. And Kristen, of course, you're the chair. I mean, I imagined we would just go through them in order. And then, and as Matt said, if people have additional suggestions, we could take them after that.
Sure. I think my proposed way of handling this agenda, I think first we're going to take up the title. And then after we take up the title, I think that the best way to go through this is just to go through the, using the staff memorandum, which I know we'll be able to put up on the screen. Go through the recommendations and really, the individual items with their recommendations one at a time. Some of the comments that we have received seem to relate to particular recommendations, at which point, at least for the most part, I think people are on the phone or on Zoom. And so I will rely on individual members to raise those comments. But then there are some that are not specific to particular recommendations. And I propose we just take those up after we've gone through the recommendations one at a time, if that seems sensible to people. So with that, I think we are going to go ahead, John, please.
I'm sorry, there was one thing that, based on what you said earlier, that I meant to mention. I am a public member of ACUS and I'm a member of this committee, but Matt, can you just confirm? I think under the rules, I'm not supposed to vote because I'm the project consultant.
Yeah, you are, you're disqualified, I guess would be or rather than being disqualified, if you'd like to just recuse yourself now, if you don't like the word disqualification, but yes, that is the case.
I think if I am not disqualified, I think recusal would be appropriate. So I'll offer my thoughts on what comes before us, but the rest of the committee will vote. Okay.
Sure. Okay. So with that, I think that means we're going to start up by taking up the title. I know that Matt had some additional comments that he wanted to make with respect to the title. And then I will call on Ron Levin after that, recognizing that Ron has to leave to go to a meeting or to teach. Matt, please.
Excuse me, Kristen. This is Paul Cameron, Senior Fellow. Can I make a quick comment?
Sure, go ahead, please.
Yeah, before we get into the weeds in terms of each of these excellent recommendations, I made a short comment back in December that's basically an a priori type question, and that is for those statutes, organic statutes that do not provide for judicial review nor preclude them, would we want to also include in any recommendation for an omnibus that Congress provide which court review should be in, whether it's at U.S. District Court, D.C., Court of Appeals, and that they follow all the other recommendations. I just wanted to get that out of the way first before we get into the details of harmonizing all the various different express statutes of judicial review.
Actually, Paul, with apologies, I would like to take up that question rather than taking that up first. I think I would like to take that up after we take up the individual recommendations.
Okay, that's
Before we
fine. I
get
just
to
want to
the
make
individual
sure
recommend-
marker on that. Thank you.
Sure, I've got it on my list. But before we take up those individual recommendations, I would like to go to the title. So Matt, please go ahead, and then I'll recognize Ron Levin.
I'd rather hear from others. I think that we've heard some complaints about the sort of use of the protean word fairness. I personally have some aversion to anything in the title that suggests that there are traps all over the U.S. code for the unwary. And so that's really all I have. I know I think Ron Levin had what was a good suggestion, and maybe John Duffy as well. So I'd rather just hear from others on that subject.
Okay, in that regard, I'll recognize Ron Levin, after which I see Don Elliott's hand, and you mentioned John Duffy. And so John, if you'd like to raise your hand or otherwise indicate, I'll hear you after Ron and Don. Go ahead, Ron.
Okay, well, I will do this on a hit and run basis because I'm about to leave, but what I suggested was that you could call the recommendation clarifying judicial review statutes, or simplifying judicial review statutes, or clarifying and simplifying judicial review statutes, whatever you prefer. And you can tweak it any way you want, but I think that comes closer to the spirit of what we're trying to do here.
Don Elliott.
I agree with Ron Levin. I think clarifying requirements for judicial review would be better. I think the title about procedural fairness in judicial review is a little bit too broad and maybe grandiose. So I think clarifying or simplifying or standardizing, I don't really care among those, but I think something that is a little bit more indicative of what the project is really about would be helpful.
Professor Duffy, please.
Yes, thanks. I had to refresh my recollection as to what I proposed back in December, but it was fair and reliable access to judicial review. I certainly agree that fair should be struck because I'm not a fairness guy. Never been a fairness guy. So I don't know how. I must have had a real bad day to put fairness in a suggestion. I think Ron Levin's suggestion is pretty good. The only thing I would suggest is keeping the word access, because it sort of focuses down on what this project is doing rather than other things. You know, judicial review covers a lot of things, including availability of judicial review, which this topic is not really dealing with. It's not dealing with, for example, preclusion of judicial review. So I think we might say this is dealing with access to judicial review. I like either simplifying or clarifying. I think clarifying is actually quite good. Clarifying, I would say statutory access to judicial review. I like the word statute which Ron Levin put in there. So I guess that's my reform suggestion, but I see Ron might have a reaction to that.
I was just going to say, I think the word statute does belong in there, contrary to what Don might have been suggesting, because there are a host of issues about judicial review that we don't intend to talk about. We want to talk about the congressional language and its possible defects.
I agree. And I think the word statute or statutory, I suggest statutory access to judicial review. What about that, Ron? Clarifying statutory access.
No, I was clarifying judicial review statutes on access to the review, maybe.
Okay.
But I'm
Can I throw in a plug for standardizing? Don suggested that, and I really like standardizing because part of what this seems to be about to me is about trying to, even though we're not suggesting that every judicial review statute has to be the same, we're talking about coming up with sort of a standard framework so that you pick and choose among the available options.
Yeah, I think that's credible also. And with that, I will.
My reaction to that is clarifying or standardizing is, you know, I'm comfortable with either. I would mildly fight for, if that can be said, including the word access. But I definitely agree with Ron Levin that the word statute or statutory, and he actually, the suggestion he had, which I have to think about, but I think it was, I guess would be with your change, standardizing access to statutory judicial review or statutes granting, or
Maybe standardizing statutes granting access to judicial review, but we've got a couple people in the queue here. So let me call on Steph Tatum and then Don Elliott.
Sure, just very quickly, this is somewhat of a sentimental point, but you know, the concept of this project harkens back in my mind to Judge Katzman's statutory review program. And for that reason, I like the statutory formulation of whatever the title ends up being.
I think we have broad consensus that we want to include either the word statute or the word statutory. I don't hear anybody suggesting otherwise in that regard. So I appreciate that vote and continued vote in favor of that. Don, please go ahead.
Yes, I just wanted to clarify that I am not opposed to including the word statute or statutory. I favored it. If I left it out, it was unintentional. I would also say that I don't think we need to decide between clarifying and standardizing. I think we could, and I would advocate we have them both. That we're talking about both clarifying and standardizing statutory requirements for judicial review.
Fair enough point that. Bill Funk, please.
I'm going to make a plea against standardizing because I think it suggests something that we're not doing, which is to make everything the same. And Kristen, you noted that we were making our checklist on different things, but the idea, I mean, I also think of to what extent we could actually get Congress interested in passing this. And I think clarifying something would be, who could object to clarifying? When you start talking about standardizing, that makes it sound like you're going to make everything the same. Even if you get into the details, it won't be all the same. But nevertheless, I'm worried that that title suggests that everything should be the same. We're not suggesting that everything should be the same.
I take your point. I think it's a valid one. With that, I have no objection to dropping standardizing because I do think the primary purpose of the project is to clarify. And I will readily concede that saying clarifying and standardizing does to some extent seem to me to be a little bit, our title's getting longer and longer. In any event, and any law professor will tell you short titles are better. In any event, okay. So Andy Vollmer, please go ahead.
So good morning. And Kristen, I'm sorry to come in at the beginning. I had two thoughts about things to add to your agenda, but I don't know. I mean, to me, they're logically before we get to the specifics, but you might want to deal with them much later. So I can mention them quickly. One is, I think that John's report talks about how we're going to direct people's attention to both this new general statute that we're talking about, as well as provisions that might be in the underlying organic statute. But I don't remember whether he did, what he said, but I wonder about that question. And can we do anything so that people are not confused? And then the second item was whether there was any thought about placement in the US Code of this general statute. Was the thought to make it part of the APA, to get it like close to the APA? So those might be outside the boundaries of our project, in which case, please tell me, or those are items that we can come to later if you think we should talk about them.
Andy, thank you for raising those very much. I do think I'd like to put those off until after we have gone through the recommendations. I think that there's a collection of broader points once we have settled on, at least preliminarily, and gotten some more feedback with respect to the recommendations themselves, either adding to them or talking about how to make them more effective globally in this sort of a sense. I think those are things to talk about after we've visited the specifics of the recommendations. Getting back to the title then, I think where we're at, and people can correct me if I'm wrong, is something in the vein of clarifying statutes granting access to judicial review. I'm seeing at least a couple of thumbs up. I don't know, and Matt and John, I will take your thoughts on this, whether we are at a stage with this project where whether we need to vote in favor of a particular title, or whether this is just a stage where we're recommending and we'll leave the voting to the next meeting. While you're thinking about that, I see John Duffy has his hand up, so let me call on John Duffy.
So I'm okay with that title, although Stephanie, we did have one member, Stephanie, voiced support for the word statutory rather than statute. So as an alternative, I'll just throw out there clarifying access to statutory judicial review as an alternative. I'm fine with either of them, but I was sort of taking notes and trying to sort of pull together anybody who had a sort of objection, sort of note that. So anyway, that's my notes on what the consensus position would be. I don't think that there's a whole world of difference between the two, but Stephanie did have the idea of history associated with it, and she's giving me a thumbs up, and I really love thumbs up in any kind of social media kind of situation. So
I like the thumbs up button too. I guess one question I would have along those lines is, in my own mind, I don't know what statutory judicial review means. As a concept. So I appreciate the sentiment in favor of statutory. I find that term confusing, but I'd be interested in hearing other thoughts on that. John, do you want to respond first? And then we've got hands from Don Elliott and Bill Funk.
No, I'll let what others, I don't understand the sentiment, so maybe I'd like to hear what other people think, because when I talk to my teach students, I talk about statutory judicial review, and then I talk about non-statutory judicial review, which could be directly under the Constitution or bills in equity and other things like that. So
I may be completely out to lunch on this one. I talk about judicial review statutes, but I don't talk about statutory judicial review. Well, so it may just be a difference in experience, but that's why we have collaborative decision-making here. Don Elliott, please go ahead.
Yeah, I think John made my point. There are non-statutory forms of judicial review. And I'm also a little concerned about the notion of statutes granting access to judicial review. It may imply that there has to be a statute, and that's not the case. And there's also as everyone knows in the case law, a presumption of judicial review. So I would want to try to avoid the idea of granting access. Maybe we could talk about statutes providing for judicial review, but there are a body of other approaches, including mandamus and some of the old common law writs that can be used. So there are non-statutory forms of judicial review.
Fair enough. I think one of the things I was trying to do was include the word access, which some people liked. But I'm also fine with providing, I'm fine with discussing, I don't know. Bill, maybe you can help us through this quandary.
Well, I liked statutory access, right? Clarifying statutory access. That doesn't rule out non-statutory judicial review, but the idea of clarifying statutory access to judicial review. I think that's exactly what our proposal or recommendations would do.
Okay, so we're now debating clarifying, I like that, clarifying statutory access to judicial review. Let me circle back to John Duffy and get his reaction because I see his hand up again.
That was a thumbs up. So I was just giving thumbs up to Bill Funk's suggestion and signing on to it.
Kristen, may I just add one point? I agree with John, and he, of course, has a lot of expertise on the issue of statutory review versus non-statutory review. I think maybe he's got this sort of leading article on the subject. But in any event, just one question. Apropos of Bill Funk's point that this statute is this recommendation will be directed to Congress. Should the title, at the risk of making it longer, and it's just a question, it's not an argument, should the title make reference to judicial review of agency action to make clear what we're talking? We're not talking about review of federal statutes. We're talking about really, rules and adjudicative orders, but should it be qualified with an eye towards presenting this to Congress?
I will support that myself, in the sense that, I haven't been thinking of this in terms of marketing it to Congress, although we probably, as other people have observed, we probably should be thinking of it in terms of marketing it to Congress. And that sounds to me like a good suggestion that will make it both clearer as to what we're talking about, but also be a successful marketing point. So right now I have as the title, clarifying statutory access to judicial review of agency action. I welcome any additional thoughts, suggestions, objections, amendments, etc. But at the moment I am only seeing thumbs up. So for now, and I even get a heart from Don Elliott. I love this. Okay. So with that, I think we'll stick with clarifying statutory access to judicial review of agency action. Thank you, everyone, for your input with respect to the title. And with that, I would like to turn to the first of our recommendations.
Kristen, may I just jump in real quickly here?
Go ahead.
I don't think it's so long as I don't think the committee needs to take a definitive vote on the title at this point. I think it's sufficient if you sort of declare a consensus, and I think that's enough for us. And here I need to defer to Reeve and Sean for the office of the chairman, maybe with the consent of the council. I don't know about that, to change the project name to what the committee consensus is. Sean, am I close here, or is that good enough from a governance?
Yes, for an office of the chairman project, sure.
No, is it okay? No, this is not an office of the, I don't mean that this is an office of the chairman project, but is the office of the chairman, can the office of the chairman just take the committee's recommendation and change the project name at this point?
At this point, yeah.
Okay. All right. So we will change, Reeve, if you have no objection, we will change the name of the project on our website and so forth, in our other materials and communications to what the committee consensus seems to be.
Sounds good.
That's great. Is there, let me raise the question. For clarity purposes, at least for now on the website, do we want to say formerly known as?
I don't know the answer to that. I don't know. I don't know what we normally do.
That's not our usual convention.
That sounds confusing.
Yeah.
I'm fine with not doing it. I just thought I'd throw it out there as a question.
I
don't really,
been so much,
whatever seems most appropriate to you all.
I don't think there's been so much publicity that there's a lot of attachment to the former name that we would need to worry about.
I think we should only do that if we change the title to an unpronounceable glyph, something that, is just a symbol, and we do that, and that would be a good idea. But I had to throw that in there because it is April 1st. We could do that for one day and it would be great.
Kristen, also, if the committee at any point could, before a final vote on the recommendation, could come up with a different title name, so maybe someone has a revelation in the middle of the night, Maybe someone can back us into an acronym of the sort that's very attractive on Capitol Hill. But in any event, this isn't set in stone. We're really just at this point dealing with the project name.
Okay. With that then, unless there are objections, I would like to turn to the first item in the staff memorandum, and the recommendations themselves. So I believe at this point in time, Bobby, are we moving to sharing the screen? There
Hopefully
we go.
that just went live.
Okay, so everybody should be able to see this at this point. So Bobby, just to be clear, the bit that's on the site at the moment that is the sort of opening bit of the memorandum, that's not the proposed preamble, is it? We don't have a preamble yet, do we?
Right, that will appear at the next meeting when we have a more formal, typical
So
draft recommendation.
Then I think we need to move forward to page 3 of the memorandum so that we can focus on the individual recommendations one at a time. And again, so these are currently set up as a staff memorandum, which looks a little bit different from our usual structure of preamble followed by recommendations. My understanding from Bobby and the staff is that our intention at this point is to go through sort of these individual items as they are laid out in the staff memorandum. And then between now and our next meeting, which for the record, I've lost the piece of paper that tells me when it's scheduled. Our next meeting is on April 22nd. Between now and April 22nd, they will be taking our discussion today and the staff memorandum and turning them into a more traditional looking recommendation document. That's correct, right, Bobby?
Yep,
okay.
Exactly right.
So for now, we are just going through, we're sort of wordsmithing in advance, if you will, and talking about these recommendations. So, so with that, turning to this first recommendation, specifying the time within which to seek judicial review, I will open it up by observing the comment from John Duffy. John, do you want to go ahead and describe your thoughts with respect to your comment and this recommendation?
Well, I'm looking at the memo also that was circulated by Bobby for this meeting, and it seems like this can be broken into two separate issues at least. So the first is actually the verbal form of using within or not later than a specified number of days. And that, it seems to me, is first on this memo that we got. I think we should talk about that. I think that's uncontroversial because it is a trap for the unwary. And John Siegel, I think, sort of nailed the issue perfectly and gave suggestions, concrete suggestions for Congress to use a particular set of words, two options, but then to avoid other options. So on that issue, I think I have no comments whatsoever other than agreement with John Siegel's suggestion.
Okay. I guess I was going by Bobby's suggestion that this would be an appropriate place to talk about including or not including the general statute of limitations in 28 USC 2401.
So if you want to talk about that, I'm perfectly happy to talk about that.
Bobby, was there a particular reason why you put that to be here, or was that just an added thought?
I tried to match up the comments that we circulated yesterday in the email to the places in the staff memo. You'll see them in marginal comments on the screen. I may have misplaced things, so feel free to go out of order if necessary. But most of them were pretty obvious where they went, but some were a little more tricky. So that might be the reason why.
In that case, I will say, John, unless you have an objection, I'd like to put off talking about this particular item because I think it is separate. So I guess at that point, then let me ask, well, Don Elliott, you've got your hand up, so please go ahead. Let's return to talking about this recommendation number 1.
Yes, with regard to recommendation number 1, John, I apologize if you discussed this in the source book. I missed it, but I think that we need to be clear about the relationship between our recommendations and Federal Rule of Civil Procedure 6, which has a number of provisions, and it does apply by its terms to any statute that does not specify a method of computing time. And it says you exclude the day of the event that triggers the period. You count every day, including intermediate Saturdays, Sundays, and holidays, but you exclude the last day of the period if the last day is a Saturday or Sunday or legal holiday. I think that can be potentially a source of a lot of confusion because technically the Federal Rules of Civil Procedure are rules of civil procedure for the district courts, and they do not necessarily apply to proceedings in the courts of appeals, which many administrative law provisions entail. Many statutes look at that. On the other hand, courts of appeals routinely cite them. So I think at least we need to be clear. Perhaps one of the ways to be clear is to incorporate these provisions so that there's consistency, but in one way or another, we need to talk about how our recommendations jibe with Federal Rule of Civil Procedure 6.
John Siegel, you want to be recognized.
That's a very interesting comment. And the comparable appellate rule, I was just looking at them while you were speaking there, Don. The comparable appellate rule is Rule 26, which, like Federal Rules of Civil Procedure 6, applies also to statutes that do not specify a method of computing time. So, I mean, I guess my immediate reaction, I hadn't thought about this previously, my immediate reaction is we need to think about how this recommendation would work with or not work well with Rule of Civil Procedure 6 and Rule of Appellate Procedure 26. I'm not sure whether it's necessary to say anything. I mean, I think you've raised the important and useful point that we need to review how this recommendation works with those two rules. I'm not sure what, if anything, we need to say in the recommendation. I mean, my immediate instinct is that this recommendation covers something that would not be assisted by Rule 6. I mean, if you're in a situation where the statute says you must file your petition for review prior to 30 days or before the expiration of 30 days from the agency's action, I don't think Rule 6 or Rule 26 would get you anything extra. So I mean, let me just put this back to you. What would you think we need to say to deal with the operation of this recommendation in conjunction with those rules? What else does need to be said?
Yeah, I think that's a really good question. And my point was really that we should consider them. I do think that Appellate Rule of Procedure 26 is more directly applicable. I think it's just a potential for confusion, John. And it may well be something that we can adequately address in the preamble. I think whether or not we need to address it in the recommendation depends a little bit on what the recommendation, how the recommendation is framed. But I think if we don't address it one way or the other, it's going to be the subject of rather unproductive litigation, in which parties will argue that under the federal rules, you exclude the triggering date, and under certain circumstances, you exclude the ending date. And I just think we need to address the relationship between our recommendation and those provisions that would otherwise apply. If a statute is enacted that addresses all of these issues for how to count days, it doesn't become, it's not a problem because by the terms of the rules, but they don't apply. So I just think it's something we need to put on our agenda, and I leave it to the Committee on Style and the consultant whether or not it's addressed in the recommendations or the preamble. But one way or the other, we need to make clear the relationship.
I like the idea of addressing it in the preamble. The only other thing I could think of might be with respect to the if we decided upon looking at it that something should be included in the recommendation itself, we could just include something to the effect of, not intending to create problems under the Federal Rules of Civil Procedure or the Federal Rules of Appellate Procedure. I don't know exactly how that would be phrased. But that does seem like something that between now and April 22nd can be taken up in the preamble or otherwise, and then perhaps revisited at that time. Any other thoughts with respect to recommendation 1 before we move on to recommendation number 2? Okay, I'm not seeing any hands. We have been going for almost an hour at this point, so I think I would like to take a 5-minute break, and then we will reconvene at noon Eastern, which is 11 a.m. Central. I don't know if anybody's in any other time zone, but hopefully you can do the math accordingly. So 5-minute break, everybody. Okay, coming back together again. So we were next going to move on to recommendation 2. So we need to scroll down a little bit. Again, John, even though Bobby's got these comments here, to the side, at least, with respect to your comment, unless you disagree with me, John, I think that that's separate rather than really being part of this recommendation 2, but I'm happy to hear you if you think we ought to take it up here.
No, I agree with you. It's separate.
Okay, then let's just move on to looking at recommendation number 2 itself. So I do see that we have a comment from Ron Levin that, let me see how this, let's see. So we're talking about here. John Siegel, are you still with us? John may not be back yet. I would like to get John's reaction to the comment from Ron Levin. I suppose, let me see, in the meantime, while we're waiting for John Siegel to rejoin us, let me see if we have additional thoughts regarding this particular comment. So specifying the action that starts the time for seeking judicial review, we're talking about where the event is the promulgation of a regulation. Congress should provide that the time starts from the date the regulation is published in the Federal Register. The concern, and I think that John had addressed this a little bit in his opening remarks about the date of the publication in the Federal Register and whether that created any confusion. John Siegel, let me ask you if, in response to Ron Levin's comment, are there changes that you think need to be made at this point, or is that something that you'd like to take up between now and April 22nd?
Thank you for asking. I think this could simply be, you could put a comma and saying, and the date of publication should be the date appearing on the issue of the Federal Register in which the regulation is published.
So I'm sorry, let's see, should provide that the time starts from
the date the regulation is published in the Federal Register, comma, and that date should be the date of the date appearing on the issue of the Federal Register in which the regulation appears.
I would offer a small friendly amendment, just to say, after the comma, change and that date should be to that date being.
That's fine. Yeah, Ron Levin had just raised the issue. What happens
Right.
the Federal Register posts the regulation on its website, which in fact it does. It is routinely posted on the website the day before the day it actually appears in the Federal Register. And as is mentioned in the source book, I found a case which said that that date was the critical date, which seems particularly unproductive in my opinion, because that's just really setting up a trap to say that the critical date is the date before the date on which it actually appears in the Federal Register. I mean, luckily that didn't hurt the party involved in that case, but it could have.
Sure. No, I think it was an excellent point. John Duffy, you have your hand up, please.
Yeah, I'd make just one. I agree with this change. I just make one small suggestion that's consistent with Ron Levin's original suggestion, and I agree with it, which is he suggested the date on the page. And I think the concept of an issue of a Federal Register might be becoming archaic. Who knows what the issue might mean as things become more virtual. The Federal Register used to publish these little issues every single day, but I think it's just clear, like if you send to some young associate, a partner could say, well, which issue was that? I know there's the page date here, which appears on the top of the pages, but are you sure that's the issue? I just seems to me like you could say the date being the date appearing on the page of the Federal Register, and then I guess on which rather than in which would be a technical correction to make that grammatical. So I'd prefer that, but I think it's a little clearer and more consistent with what Ron suggested.
Does it need to be first page to the extent that some regulations appear on multiple pages in the Federal Register?
Well,
or should it be pages? Because I guess they would be consistent throughout.
It should be consistent throughout. You raise the point that what if the agency publishes its regulation in two parts, one on one day and one on the other day? You could put it, the date appearing, the latest date appearing on the pages on which the regulation appears, so that if the regulation is spread out, its publication could conceivably be spread out over multiple days if it's a particularly massive regulation. It seems like then you say, well, it would seem unfair to say you have to sort of start counting when the final part of the regulation that you're going to challenge is not yet published. So maybe that's a way to deal with that problem. If you do first page, that does set up the possibility that it could be, the time could be expiring before the agency coughs up the whole regulation in the published pages.
Let me go to Allison Ziva, please.
I just wanted to say I find this edit super confusing. I'm just not really sure what it means. If you tell me it starts from the date when the regulation is published in the Federal Register, I know what that means because I can go to the Federal Register site and it clearly says publication date. But the new clause that we've added, I'm lost in there. I'm not sure what's ambiguous about when it's published in the Federal Register, when the Federal Register states a publication date.
That's an interesting point. I mean, so as John pointed out, Ron Levin's original point was that, sometimes it's published by the Federal Register online on a different date than it's published in print by the Federal Register.
It's made available online, but then it has a official publication date of the printed version. it looks like the old, well, I call it the old, maybe that just reflects John Duffy's comment about how the Federal Register, the printed version is sort of becoming an anachronism, but they do publish online what looks just like the printed version, and that has a publication date that is stated on the online version, and that is the official publication date for the Federal Register. And that's the date that we've always used, including, you know, in the past many years when we haven't looked at the paper version. That's the date that everybody goes by for figuring out when your time starts to run.
Let me ask for some additional voices here, but point out in the meantime, particularly to John Siegel, who I think has been in closer communication with Ron Levin than I have on this topic. The questions that's raised in the chat is whether we have a cite to the case that counted the date before publication as the starting of the running of the time to appeal, and whether that might shed any light. I don't know the answer to that question. Go ahead, John Siegel.
The site is in the source book. It's not in the recommendation, but it's the case I had in mind is Public Citizen versus Mineta, 343 F 3rd 1159, 9th Circuit, 2003. And does that shed any light on the drafting question we have here? I think not, because that case was responding to a statute which said the time runs from the date the regulation is issued. And the court construed issued to mean made publicly available. And they thought that the Federal Register had sufficiently made it publicly available on the date it was made available for public inspection, even though that was not the publication date. Now, getting back to what Allison Zeev said, you know, she raises, I think, a good point, which is maybe we're just doing something that is the opposite of what we're trying to achieve here. And I will mention when I queried the ACUS member for the Federal Register on this topic, I said, you know, how can we better define what the publication date is? I believe the first sentence of her response was, I was unaware that there is any ambiguity in the concept of a publication date. So, you know, maybe we're being too cautious and just doing something counterproductive, and maybe the original text was fine. That's what Allison thinks.
Actually, that's a very interesting point about if the case focused on the statute using the word issued, and we are particularly recommending that the statute include the word published, that might resolve the issue in and of itself. Allison, I cut you off. So Allison, please go ahead. And then we've got several other people in the queue who wish to be heard on this point.
First of all, that case was complicated. It was a Hobbs Act case. There were people, more than one plaintiff or petitioner that had different statuses because some had moved for reconsideration, if I recall, and another one hadn't. Anyway, it was complicated. I wondered if we could clarify it to the extent it needs clarifying by saying to the date of the publication date of the printed version of the Federal Register, since if you look on the Federal Register's website, it specifies the publication date for the printed version, and that's what currently is used. I mean, putting aside that one case from 2003, but what we all go by is the publication date of the printed version. I think the agencies agree that's the right date. And since it's easy to see right on the website, because it says right on there, document details, printed version, PDF, publication date, you know, states the date, agency. So of course, the Federal Register can change how it does the website, but there'll always be a publication date for the printed version as long as the Federal Register is still doing its job. I mean, it's required by statute to do that. So that's my suggestion.
Bobby, could you please type up in here just as a possible alternative? I don't think we're ready to replace anything yet, but I think it would be the time starts from the public publication date for, in the publication date in the printed let's see, publication date for the regulation in the printed version of the Federal Register would be how that would read, I think, as a possibility. So let's just leave. Yeah, I think we've got it fine. This gets all the options on the page, at least for people to look at. Let me now turn to Don Elliott, please.
Sorry, it took me a minute. It took me just a second just to unmute.
No worries.
So two separate issues. I think this is focused on the initial promulgation of a regulation, but frequently we're talking about an amendment of an existing regulation. So I think we should say where the event is the promulgation or amendment of a regulation. I don't have a view with regard to the language about the latest date, but if we include that language, I think we have to worry about corrections. Sometimes a regulation comes out and then there's a correction. And if we do include the language about latest date, I would suggest we should talk about the latest date on which the provision challenged is, or the provision that is the subject of the petition for review is published in the Federal Register. You do occasionally have situations where an initial regulation comes out and then later there is a correction or modification that comes out. And if somebody is challenging the provision that is published in the correction or modification, then I think the time should run from the time that appears.
That does add a complicating wrinkle. You're right, Don, with respect to corrections, particularly if you've got different dates for, if you've got more than one provision being challenged in a particular case. I can see this getting complicated very quickly. Next in my queue, I've got Kenny Wright.
Thanks. I just wanted to express my support for Allison Zeeves' proposed change. I think that publication date is the term of art for the Federal Register. When you're talking about the online publication, I think that's typically referred to as the public inspection date, which is provided for in OFR regulations and occurs one day before the printed version. So it's odd that a court would allow judicial review to sort of be modified by the public inspection date. But I think Allison has captured what I think is the important point and is the sort of term of art used by the Federal Register.
Bill Funk, John Duffy, I have you next in my queue. Then Bill Funk.
Yeah, I was just looking at the Federal Register because my memory I never trust my memory basically about exactly what it says. It's interesting that online it gives something that says publication date : and then a date. The printed version doesn't do that. It just has the date at the top of the pages and the top of the regulation, but it doesn't say publication date. So it's a little, and even Allison said, publication date is clear on the online. She actually stated it correctly. She said on the online, it's clear what the publication date is, but it's sort of odd to have then the printed version, because it doesn't have something that's expressly denoted publication date. I think it's probably clear enough if you say the publication date listed on the printed version of the Federal Register, because it doesn't have to be the actual publication date if there's some sort of suspension of the actual physical publication. If there is any physical publication of the Federal Register anymore, that would not matter. All that would matter is something that's listed on the printed version. And I think these days, we would think printed version includes PDF version. But it's some controlling feature. We want some controlling feature on a single document, not, I think, on a web page.
Okay, so at this point, we have two different issues going because there are some people who want to talk about Don Elliott's proposed addition of a reference to amendments of a regulation. I would like to leave those questions or comments to the side for a moment. We will come back to them and focus instead, if we have additional thoughts regarding this publication date question. With that in mind, I see, so Alan Morrison, I will come to you in a little bit, but otherwise I have Bill Funk, Allison Zeeve, and Dick Pierce.
Well, come back to me because I wanted to talk about something other than what
I will absolutely come back to you. Let's just leave your hand up. Allison, please go ahead.
I just wanted to say that the publication date listed on the website is the same as the date that you see at the top of the page on the printed version. I'm not sure if John Duffy thought they were different or if that doesn't address his concern, but those two dates are the same. And then I just wanted to comment about, to the extent all this is connected to that 2003 case that John mentioned, the reason it turned on the word issued is because of the specific provision in the Motor Vehicle Safety Act that said it was, you calculated from the date it was issued. And the reason that was discussed in the case is because the Department of Transportation was arguing that it was issued the date it was signed as opposed to the date that it was published or sent to the Federal Register and made available. And so the argument that the disagreement in the case was not about the question we're having now about what it actually means to publish in the Federal Register. It was about whether the 60 days started to run like from the date the Secretary signed it before the public even knew about it. So I just think to the extent we're focused on that case, we should, which I'm not sure we are, but I don't think that case really matters to what we're talking about so much here.
So it's a random outlier of a case, in other words.
Well, the government was making an argument that I don't think we need to be concerned with, and I don't think it makes any more.
Okay. Let me remind people that if you could avoid putting substantive comments in the chat, I would very much appreciate that. What I'd like to do at this point is call on John Duffy, then Dick Pierce, and then Boris Berstein. Since you've made a substantive comment in the chat, I would appreciate it if I could call on you to help elaborate that point. So John, go ahead, please.
I just wanted to say in response to what Allison said, I certainly understand that the publication date listed on the website and on the pages, the physical, or not physical, maybe somewhere, but PDF version of the Federal Register are supposed to be the same. And they are the same, almost always, maybe always. But as lawyers, I want to know what's the right rule if I have a divergence between those two. I want one of those dates to control. And that's why I try to say it should be on the printed version so that somebody looking at that doesn't fall into a trap if there is a divergence. That's all.
Let me call on then Dick Pierce, please.
I actually had a comment on Don's suggestion. So if you come back to me, I will say though, as long as I'm here, I agree with Allison generally that I think keeping this simple is a plus.
Well, let me ask this question then. So actually, let me call on Boris and then I'll ask my question.
Thank you, Kristen. I was just going to make the simple point that there are provisions of the Federal Register Act that make reference to certain dates. I haven't, kind of live worked through all of them, but if there are dates there that ought to be that are by statute made notation of, like the date of the certified copy that a document is filed with the Federal Register, we may just want to make sure that we're giving due attribution to those, especially if they have some relationship to what's clearly displayed on the Federal Register website.
And perhaps that's something that we can look into between now and April 22nd. Let me raise my question and then I'll hear John, then I'll call on John Siegel. I guess my question is for those people who would like to keep it simple, whether saying that Congress should provide from provide that the time starts from the publication date for the regulation in the printed version of the Federal Register. If we left it at that, would that be simple enough and eliminate confusion while still resolving the possible, issue if there were, if there were a discrepancy between online and otherwise? We've talked about a lot of different possibilities, and I don't know empirically what the likelihood is of any of them in terms of, public regulations being published on multiple days, et cetera. So I don't have a strong opinion here, so much as I'm trying to get us narrowed down to something that we can resolve, at least for now. John Siegel, let me call on you, please.
Thank you. First, I just wanted to go back to what Allison said last and say, yes, Allison, I agree with that. And indeed, if you look at this section in the source book, the main point that I was trying to get at here was to get at those cases in which the government argued the date that a regulation was issued, which was made, where statute said that's the key date that starts the time running. The government in some cases made the argument that that was some internal event that occurred at the agency, and that was the key date. So that's the main point of my suggestion in this recommendation, is to defeat that and to use the publication date instead. Then since then, Ron Levin raised this question: is the phraseology I used, the date of publication, is that sufficiently clear? And now, as you see, we've had this rather lengthy discussion about, how could that be made more clear? So my suggestion, based on what we've discussed so far, is maybe I should now go back again to the ACUS Federal Register member and ask for her expertise as to what phrase would best encapsulate a clear rule that we can recommend for the statute.
Allison?
I just wanted to comment not on the part of the recommendation that we keep debating, but on the beginning. If what triggered this was that issue about issuing date, then maybe we should say the date on which the regulation or amendment is issued, as opposed to using promulgation. I don't know that there are statutes that use, John will know, but are there statutes that say that the date that triggers it is promulgation, which just seems like something maybe we all just say? But I know there are, at least a couple statutes that do say issued.
Right.
So if that was the triggering event, and John, unless there are other statutes that say promulgate, maybe we should switch that word.
Maybe that should be issuance. Yes, honestly, I'd have to check. I could check in the spreadsheet whether the term promulgation as opposed to issuance is used. I mean, neither of those terms is used, because the term that would be used would be a verb rather than a noun. It would be when the
right. So it'd be issue or promulgate, not issuance or promulgation.
But for
how about, let me offer this suggestion for now. How about, so if, we have all of this language up on the slide at present, which it surveys a variety of options. Before promulgation, let's put in brackets issuance and a slash and close the brackets. Just to remind John of what we're looking at as, we work toward formulating the actual recommendations with the preamble. Let's also put in brackets everything after the comma at the end of the sentence. So starting with that date being, there you go, or putting the comma there, or the brackets there, that's fine. And let's leave it at that so that we can get this sorted out between now and the 22nd. This may also be an instance in which having a preamble will be helpful, in that the preamble may allow us to articulate what is prompting this particular recommendation by reference to, issuance versus publication, et cetera. And it may be that helps us solve this problem. This at least sort of resolves this gives us something to work with between now and the 22nd that we don't need to necessarily resolve today. Does that seem a sensible approach to people? John Siegel, I see you have your hand up.
That's from earlier. I'm sorry. I just neglected to take it down.
Okay, I'm trying to keep up with that myself. Allison, do you have anything further at this point?
No, I think I talked myself and all of you out enough on this one. Thanks.
Okay, with that, then I think, oh, Alan Morrison is waving and Bill Funk are waving. Well, I was going to go on to amendment. That was the next issue. Bill and Alan, do either one of you want to be heard further with respect to this publication date versus issuance date question? Okay, I'm seeing shaking of hands or heads. So let's move on to talking about the or amendment point. And let me start with Bill Funk there.
Well, what I wanted to talk about was what Allison raised, which is, and not just issuance, but adoption, because I'm pretty sure there's some statutes refer to adoption of a regulation. So issuance, adoption, promulgation, or similar language is really what we should be concerned with.
Actually, I think, Bobby, that the adoption should go with issuance rather than amendment. And I will leave that to John Siegel to figure out between now and the 22nd. Okay, with that, Alan Morrison, please.
Thank you. Took me a while to figure out how to do the hands raise in this particular version of Zoom. I was teaching my constitutional law class before, so I missed the first recommendation, but I'll pick it up at some other time. So I don't think we need amendment because if we put amendment in, we're going to have to put repeal in there. And the APA defines the issuance of a rule as the issuance, amendment, or repeal of a rule. I don't think anyone will be confused by that. And even the example that Don gave about the amendment coming subsequent, I think that we've identified a basic problem, which was the issuance problem. I don't think the courts will have the slightest difficulty, nor will litigants have the slightest difficulty in dealing with this in the real world once we get this basic approval. And I urge us to keep it as simple as possible and not include amendment there as well. Thank you.
Don, you've raised your hand.
Yes, I just wanted to respond to that. I would not, I agree with Alan in terms of keeping it simple, and I would suggest that we could certainly clarify that the language of promulgation includes revision of an existing rule. I would also just point out that 307D of the Clean Air Act talks about the promulgation or revision of various kinds of rules. So I would suggest that that's not too complicated, and the word revision, has an existing meaning that includes both amendment and repeal or revocation. So I don't feel strongly about it. If you want to define promulgation to include these other categories in the preamble, that would be fine with me. But I would suggest that we consider the language that exists in 307D of the Clean Air Act, promulgation or revision of a regulation. I don't think or revision makes it too complicated. I do think that issuance is a real difficulty, and I agree with what I had understood John Siegel to recommend initially, and that is that we be clear that it is the publication in the Federal Register rather than some internal event at the agency. I guess I disagree with Alan on that. I think there's a lot of unnecessary litigation about whether or not a regulation is issued at the time it's signed by the administrator or whatever. So I think having it be clearly the promulgation or revision of a regulation defined as when it's published in the Federal Register would be a helpful clarification.
Bill Funk, please.
Taking Alan's point, which is that the APA defines rule to include all these things, do we want to change the word regulation to rule?
Is there any possibility if you change regulation to rule is there any issue that's raised by potentially capturing non-legislative rules? I don't know that there would be necessarily. I'm just posing the question. Maybe not.
And I would say no, because if indeed you published a interpretive rule or statement of policy in the Federal Register, and it was something for which you could get judicial review at a time limitation on, we'd want this to apply in any case.
Fair enough. John Siegel, you've got your hand up. Please go ahead.
Yes, just to answer, basically agreeing with what Bill just said, Kristen, in answer to your question.
Yeah.
Remember, we're dealing with those situations in which there is a statutory time limitation that is triggered by the issuance of a rule. So if there's a statute that says you can get review of an interpretive rule within a certain time, we would want this to cover that as much as a legislative.
No, that seems sensible. And I do notice that C goes on to talk about, well, it's talking about rule in a different sense. I guess then you run into a question about, is there confusion by using rule in B to mean as a substitute for regulation, but then use the word rule in C to mean something different?
Yes, we'd have to think about that drafting. But I also just wanted to say, going back to Allison's question, are there statutes that say the time runs from the date a rule is promulgated? I did a quick check while we were talking, and the answer is yes. Particularly, I found a bunch in 15 US code that run the time from the date of the promulgation of a rule. So that term is in fact used in some of these statutes. That's the advantage of having a big spreadsheet of all these statutes. I can check these things.
Gotta love it. Okay, Don Elliott, please.
With regard to rule, again, I think that can all be clarified in the preamble, but I had not understood the recommendation as being limited solely to rules. And I would just remind all my colleagues of what they know, and that is that the APA talks about final agency action. So we can have judicial review of things that are not within the category of rules. Don't we intend these principles to apply to those as well?
Our final agency, well, yeah. I don't know, something to think about in any event. John, I can't tell if your hand is still up because you left it up or if you had something to add.
In response to what Don just said. I mean, 2A, the principle that Congress should clearly specify what the event is that starts the time running, that applies to everything. 2B is just attempting to deal with a particular problem I discovered in the cases that there was the language that Congress sometimes uses, that the time runs from the date a rule is issued, has led to particular problems. And I think, you know, for those statutes that say from the date the rule is promulgated, you could have this same question. Again, the specific question I was trying to address is, should that date be taken to be the date the administrator at the agency signs the rule, even though the public may not even know that that has happened, or should it be the date it appears in the Federal Register? And it seems to me that the latter date is the date that I think most people intuitively imagine to be the date a rule is issued, and that should be the date. But some agencies were saying, no, it's the date we issued it, even though the public didn't even know on that date. They only found out when it was published in the Federal Register. And if you look carefully at the Federal Register notice, the agency said, and this was true, you could find in that notice what that earlier date was, but it might not occur to you that that earlier date is the controlling date. So that's the main point that 2B is devoted to. And now we're having this lengthy discussion about, you know, could we improve 2B to make it even a little clearer? And maybe we could, but the main point is it the publication date or that earlier date that something happens within the agency? That's the main point.
I will make the observation here that at least with the way that this item 2 is currently set up, it does set it up with a general problem and then a particular problem with respect to regulations that we are now broadening out, you know, where, so this item B, as John suggests, is talking about that specific particular situation. So maybe attempting to broaden it out by making it rule or final agency action is, sort of failing then to capture that particular scenario that comes through in the case law. But I will simultaneously make the point that if we decide to go with rule or final agency action, we've used regulation we use regulation in a couple of other places. And then again, we have the problem with the use of the word rule in C. Let me recognize Alan Morrison and ask anybody else to please go ahead and raise your hands if you'd like to be heard on this. But in the interest of time, I would like to move forward and get to some other recommendations. So recognizing that this is an intermediate meeting and that we will also have another meeting on April 22nd regarding these recommendations, at which we will have a preamble and we will have more definitive language based on John's additional consultation with the ACUS representative at the Federal Register. We don't have to resolve everything today, is my point. So let me go ahead and hear the people I have in the queue are Alan Morrison, Bill Funk, and Dick Pierce. And I'm hoping that then maybe we can move forward. Alan, go ahead, please.
Don Elliott is correct that there are lots of things under the APA besides rules, but B only deals with rules. So if we want to make a suggestion about anything else, it doesn't belong in B. And most of the rest of these things get done, do not appear in the Federal Register in any event. Thank you.
Bill Funk, please.
Essentially the same thing Alan said, but I want to make clear, rule isn't broadening the concept of regulation. What it is making unnecessary inclusion of revisions and repeals and amendments for the thing, because rule by definition would include that. And again, as Alan said, the final agency action that is not a rule is by definition an adjudication, and adjudications do not get published in the federal, certainly judicial review doesn't turn on it being published in the Federal Register. So it's just not relevant here.
Fair enough. Dick Pierce.
Well, these points have been raised, but if we're going to include amendment, we need to include repeal. I'm not sure we can get away with just referring to promulgation of rules, because I've just been looking at all the definitions in the APA, for instance, and there, the definition of rule does not include amendment or repeal. The definition of rulemaking does, but the definition of rule does not. So I don't know. Just for clarity purposes, I prefer to include both amendment and repeal. We certainly have to include repeal, since it seems like the first act that every new president takes these days is to repeal all of his predecessors' rules, and then they're all challenged in court. The point about other agency actions, as I think Alan mentioned, most of those other agency actions, there's nothing in the Federal Register about them, and the most frequent of them by far is adjudications. There's a few million of those, and they're certainly not in the Federal Register.
Okay, I think at this point, John Siegel, you have a lot to work with. Actually, Bobby, why don't you put /repeal after amendment, but inside the brackets? Some of this may be addressed in the preamble, perhaps. I think we can all agree that perhaps we can allow John to take these different suggestions and go forward after talking with the ACUS representative to the Federal Register. And then we will revisit this question, I have no doubt, on April 22nd when we meet with revised recommendations and a preamble. But with that, why don't we go ahead and move on to recommendation or item number 3. So we can scroll down to the next page, please. Okay, so I recognize that Elaine Middleman, as a member of the public, has raised a question with respect, or a comment with respect to this item 3, Again, I think that the concern that Elaine has raised is better addressed as a separate issue after we after we have addressed these specific recommendations. So turning to members of the committee, let me see if anyone who is on the committee has any particular comments with respect to this item number 3. Okay, I'm not seeing anyone, so I guess at that point, let's move forward to item number 4. The document that initiates review. Congress should include in the general statute a provision that a court shall treat a petition for review as a notice of appeal when necessary and vice versa. Comments? John Duffy, you've turned off your mics, or you've turned on your mic, so I assume you have a comment.
Yes, I do. Sorry, I thought you were gonna.
Okay, go ahead, please.
So John Siegel said in his comments that he did not suggest that the Congress use the phrase, bend towards the phrase petition for review rather than notice of appeal. But John, I thought I saw that in your source book. I did see that. It's not in the recommendations, but it is in the source book. Am I wrong about that?
No, that's right. I just meant I had not yet incorporated that into what this document that's before the committee, but I'm certainly open to it. I mean, I guess I would just say, we might limit it to just saying in new statutes, when Congress drafts statutes in this vein, it should use the term, it should prefer and use the term petition for review, not notice of appeal. Do we want to say Congress should go and take out notice of appeal everywhere it appears with agency action and put in petition for review? I don't know, but I certainly would feel comfortable saying in any new statute, Congress should prefer the term petition for review, because as you, John Duffy, pointed out, that makes more sense. It is somewhat, it seems like a category mistake when Congress says there should be a notice of appeal, even though that is what Congress has said in numerous statutes.
So I would certainly support that, and that's consistent with what you say in the source book too. I read what you said in the source book on this issue, and I agree with it wholeheartedly.
Yes.
So I guess that would be a question of whether there'd be an additional recommendation here. And I guess out on the margin, support that. I agree with you that it should be prospective only.
I would support including that, although as we discussed earlier, I don't really have a vote here, but my opinion is yes, that would be a good idea.
So what language should be added, gentlemen?
How about when Congress provides for judicial in a specific judicial review, let me start again. A specific judicial review statute should provide that review should be initiated by the filing of a petition for review. How about that?
Okay, I think Bobby's going to need you to read that a little bit more slowly. And I recognize this is as much a placeholder as anything, but nevertheless, having some language up on the slide gives us a basis for discussion. So a specific judicial review
should provide that review should be initiated by the filing of a petition for review. And perhaps petition for review should be in quotes, just to emphasize that the point here is with regard to specifically the name of the document, the style of the document that would initiate review.
Do we want to say prospectively a specific judicial review statute to indicate that we don't necessarily mean that we're suggesting that Congress needs to go back and amend a bunch of statutes?
Perhaps when drafting a specific judicial review statute.
Okay, Alan Morrison, you've been patiently waiting to comment, so please go ahead.
I suggest that the phrase "when necessary" in the previous part of this recommendation be deleted. I don't know when it would be not necessary or whether it would be appropriate or anything like that. I think just, and in interest of brevity, of course, always, I don't think it serves any function. When would it not be even appropriate to not do it? So,
John Siegel?
Well, I mean, the only point of when necessary is that if the statute says you initiate review by filing a petition for review and you file a petition for review, then it is not necessary to treat that petition for review as a notice of appeal.
that's true.
It is necessary in cases in which the statute says file a petition for review and someone files a notice of appeal, or vice versa.
I'm unconvinced. But not.
But don't feel strongly about it.
If I might say, Alan, I think it is a little confusing to say a court shall always treat a petition for review as a notice of appeal, because no, if the statute says file a petition for review and someone files a petition for review, there is no occasion to treat it as a notice of appeal.
Well, then maybe the quarrel is with the when necessary language. I mean, I don't know. I mean, I can't imagine it not being clear when it goes into a statute like this. But in any event, I've said my piece.
Either if when necessary might be elaborated a little bit, or again, this might be. And this question might be resolvable through the preamble. Let me call on Bill Funk, please.
Well, I thought that John Duffy proposed language in his comment, and I thought that was a very good, statutory provision that he suggested. So although there's a typo in it, but other than that, there's it's very good. I think that does the trick.
I see, I do have that. I forgot about that.
Can you help us out here? Let's see. So what would we change?
Well,
let's see.
It's lengthy. It's in my.
So would that be as a substitute for the language immediately preceding it on the screen?
That's the wrong one. That's the wrong language.
The next one.
The next one.
Not the previous one.
Or previous one.
Congress should include.
Congress should include in the general statute a provision stating that statutes authorizing judicial review by the filing of a notice of appeal. Do you see that language in your memo, Bobby? Or in John Duffy's?
Yeah.
Should have got them now. That should be the right one. Sorry about that.
Okay. We've got it twice, or we somehow ended up with two different things. Two different paragraphs. I think that should be one paragraph, the two sentences there. In any event, okay, so is that in lieu of the language we came up with on the fly?
No, it's not. I think it's in lieu of the first paragraph, which says Congress should include. I think this is to deal with the when necessary issue. It still would say that you should have another recommendation saying when drafting future specific judicial review statutes, Congress should provide that review should be initiated by a petition for review. That's a sort of separate, really semantic point with some constitutional overtones about federal jurisdiction, but that's this other paragraph is designed to be a substitute for that one. And I'm not going to fight too strongly for my own language, but if Bill Funk wants to go to bat for me,
well, I do think there is some dissatisfaction with when necessary. So perhaps this does sort of help resolve that problem.
And vice versa.
And vice versa. Bill Funk, let me call on you, please.
Well, I was just going to say that I'm trying to get language as close as possible to something that Congress could actually adopt without having somebody do it for them. And so this pretty much does it. And you don't see a statute with vice versa in it and ever. And that's a good thing.
Fair point. Fair point. Okay. Well, again, recognizing that we're at a somewhat intermediate stage with these, I think we've given John something to go on, and something that we can work with. And some of this may also be addressable via the preamble. Does anybody have any additional comments, concerns, or observations with respect to this item 4? Okay. With that, and given that it is by my clock here in the Central Time Zone, 11:54, I would like again to take a 5-minute break, and then we will come back, tackle these last 2 items and some of the additional points that have been raised. So 5-minute break, everybody. Together, if possible, please. Okay, before we move on to item 5, our fearless leader, Matt Weiner, has an announcement he'd like to make.
Yeah, I just wanted to say, unrelated to this project, Kristen, that a prior ACUS recommendation seems to be well on its way to being implemented. And I refer to a recommendation that I think some members of the committee probably worked on, and that was in 2016 when ACUS recommended that Congress, the Judicial Conference consider special procedural rules for Social Security disability cases in the district court. And as some of you may know, the Judicial Conference has spent an enormous amount of time considering the ACUS recommendation, and along the way said some very complimentary things about ACUS. The Advisory Committee on Civil Rules established a special subcommittee to consider the rules. Some of our ACUS affiliates, including our consultants and Alan Morrison, made very persuasive arguments to that subcommittee. And what I just wanted to say is that the subcommittee has now drafted and recommended the adoption of special procedural rules in accord with the ACUS recommendation. And the Civil Rules Advisory Committee will be taking up the subcommittee's recommendation at I think it's April 23rd meeting. So thank you, especially to those committee members who were around in 2016 and worked on the recommendation. And one reason I just mentioned this is that it does show that our recommendations are taken very seriously. And I hope and expect that this recommendation will be taken very seriously by Congress, just as the 2016 recommendation was taken very seriously and acted upon by the Judicial Conference. So that's all I wanted to say, Kristen, and thank you for indulging me.
Sure, no problem. Okay, moving on to recommendation number 5. Here again, we have a suggested proposed revision or replacement language from John Duffy. Why don't we, put that language, well, the language is up on the slide already. It's in the bubble comment. I guess my question would be, how about if I call on John Duffy to describe why he's proposing this alternative language, and then I'd like to call on John Siegel for his reaction to that language, if I may.
I think my major change here is the end portion. I think the first, the when clause that both I and John have, I think it's a toss up. And then the next, Congress should not specify, I think that's the same. And then the question is the very end, but should instead allow that matter to be governed by the applicable rules of court. Because this is a recommendation and not statutory language, I think that the reader who just reads the recommendation, which is what a lot of busy people might do, might say, why are we not why shouldn't Congress specify what should be in this petition for review? And this just sort of clarifies why we're doing this, that if the Congress says nothing, then it's controlled by this other body of law. So that's my view. It's I'm not going to fight to the bitter end on that.
Okay, John Siegel, can I hear your thoughts with respect to this?
That's fine with me. I do have a comment on the next paragraph in John Duffy's comments, which gets back to an issue raised, I think, by Andy Vollmer earlier in the meeting about where all of this is going to be placed. And I would just transmit a comment that was made during one of the interviews I mentioned on the Hill, which is, it could be a little dangerous to recommend any of what we recommend as an amendment to the APA or as an amendment to the Hobbs Act, particularly the APA, because as I'm sure most members of this committee know, there are various proposals to redo the APA that have been floating around on Capitol Hill for some time, and I think everyone's kind of afraid to touch the APA, because if it becomes if the APA is regarded as being open for amendment, well then the few small sensible things that we're recommending here, okay, these are fine, but once the APA is regarded as open for amendment, some very big stuff could happen that some people might like a lot and others people might not like. And I think everyone might prefer to say, let's just leave the APA alone the way we have now, ever since the 1940s when it was enacted. So I think in terms of placement, if we really want this to happen, as Matt was suggesting just a moment ago, if we really want this to actually not just be a recommendation that's issued by ACUS, but something that actually gets acted upon, I think it might behoove us to figure out some way for Congress to do this other than as an amendment to the APA, because amendments to the APA, I think, are that's just viewed as rather dangerous territory.
Okay, I take that point, and I think that does go along with what Andy Vollmer raised earlier. So let's set that aside for a moment and come back to it. Just focusing on the language of the recommendation. I take John Duffy's point that the language is very similar. I guess one question, that John Siegel's language and John Duffy's language is very similar. If I may make the observation, first off, so it's true that the first clause of the sentence is very similar. I'm wondering if, though, since John Siegel said when providing that a party may seek judicial review by filing a petition for review, perhaps then we include that, then put in a particular forum after that. And that blends what Duffy and Siegel have said. And then,
can I just ask John, do we need in a particular forum? Because some of these statutes do specify a forum and others don't.
I don't know why I put that in there, I must say, and it does seem to me like it's not necessary. So yeah, let's delete that.
Actually, if I may, one reason why it might be useful is that to the extent that you go on to talk about allowing the matter to be governed by the applicable rules of the court, different courts have different rules. So maybe that was the rationale of including in a particular forum.
How about in a court? Well, although where else would you seek judicial review besides a court?
But yeah, exactly. I mean, I think that I think the key here is to allow the individual forums rules to govern rather than Congress coming up with a different set of rules.
Well, as I said, I just wouldn't want the phrase in a particular forum to be limiting, because many of these statutes just provide that you can seek judicial review. Some of them don't specify the forum. Some of them just say you can seek.
Sure.
And I wouldn't want this not to apply in such a case.
But certainly those examples must at least tell you whether it's, or implicitly or explicitly must tell you whether it's the appellate court or a district court. So one way, the current way it's drafted on the screen says seek judicial review in a court, which, you know, could be read literally if one were a literalist to mean a particular court, which I think, Kristen, gets at your point that we're really focusing on where Congress is identifying a particular place. And if it doesn't explicitly do it, John, I think it would, you must at least implicitly, you know, from the context, be able to tell whether it means an appellate court or a district court.
I mean, I'd have to look through my spreadsheet of statutes, but I would say there are definitely, my recollection is that there are some statutes that don't say anything about the forum, which has the effect that you do it in district court because of, you know, Section 703 of the APA. How about if we take out in a court and add at the end, the court in which judicial review is sought? No, staying within the paragraph we're working in.
So at the end of that paragraph.
Can I interject?
Yeah, well, hang on one second. I want to, we've got 5 people in the queue and I want to call on everyone in the queue, but I'd like to get this at least proposed language on the slide so that we're all thinking in the same terms. And then let me go to the queue. So at the end of that sentence, John, could you please again say what you would add there?
Which judicial review is sought.
In which judicial review is sought. Now then, I do have a lengthy queue at this point. I would ask that everybody, you know, hopefully we're all the people who've raised their hands are talking about this particular point that we've been talking about. Let me start with Bill Funk and then go to Allison Ziva.
Well, if we're talking about the second paragraph, then I would say to avoid the problem that this would be suggesting Congress should say amend the APA, put a period after initiating judicial proceedings and say such matters would automatically be governed by applicable rules of court in which judicial review is sought. In other words, explaining why you don't have to specify the required content, not because Congress should provide that it be governed by applicable rules of court, but the fact that that's what would happen automatically, and therefore you don't need to amend the APA or anything else. And I assume the second paragraph is in lieu of the first paragraph. If I'm wrong, then
I think that was the idea.
Okay, because petition for review by itself isn't enough. We'd have to say notice of appeal as well.
Well, it says petition for review, complaint, or other document initiating judicial review proceedings. Do you want us to add notice of appeal?
No, that's fine. Other document is fine.
Okay.
I was just talking about the first paragraph if we were still considering it.
I see. Allison, let me go to you then.
So I just wanted to comment 2 things. One, I think in a court in the introductory phrase was a good idea to take it out. You know, judicial review is in a court, so we didn't really need both. But in the end, just to make it a little less clunky, governed by the applicable court rules instead of governed by the applicable rules of the court in which judicial review is sought, just seems like a
Well, except you don't see judicial review in court rules.
No,
Or
should be
you're
governed by the applicable court rules.
Got it. I see.
I'm not trying to change the meaning there, just to say it a little more concisely. That's it.
Yes, I just didn't understand fully what you were proposing. Thank you. I appreciate that. Alan Morrison, please go ahead.
This is, we needn't spend a whole lot of time on the exact wording of this, because this is not going to be a statute. This is going to be a recommendation to Congress. And so to the extent that we can cure any ambiguity by the preamble. That preamble will go with this. Second, I have a general point occasioned by the discussion of where this would go. It seems to me we have two sets of recommendations here. One like this, which is a general recommendation to Congress to do or not do certain things. That could be part one or part two, it doesn't matter. And then the others are specific recommendations for Congress to enact certain things. And I think it would be helpful to divide those up in this grouping when we actually get around to the final thing. I don't mean to do it now, and also to keep in mind whether we're just telling Congress what to do or not do, in which case we can be a little less worried about the details, where when we're actually talking about what language that Congress should enact, then of course we want to be very careful about what we're telling Congress to do. Not that they will do it, as we will see in the next race to the courthouse recommendation.
I think that's an excellent point, and I like the suggestion. So perhaps we can document that somewhere for purposes of when we draft up the preamble and the recommendations, that we actually have sort of a part one and a part two of the recommendations. One being recommendations just as to things Congress should keep in mind, and the other part being things Congress should enact. In any event, okay. But before I call on Don Elliott and Ron Levin, let me just make the observation here that since we're talking about the second sentence that's up on the slide under point 5 as a replacement for the earlier sentence, let's draw a line through that. Perfect, thank you. Let me call on Don Elliott then, and then Ron Levin.
Two quick comments. One, I strongly agree with John Siegel's point that we should not say a petition for review in a particular proceeding. There are lots of situations where Congress allows proceedings to be brought in more than one court, and so we could be inviting, but I guess we've gotten past that. The more germane observation is really just one of politeness, and that is, I think we should probably say something like Congress should not normally specify or not typically specify, or Congress need not specify. But my sense, and I defer to Matt and others, is that when we're making recommendations to Congress, we usually allow the possibility that they may decide to, deviate. So I would say Congress should not routinely or not normally specify the required content, just as a matter really of politeness, but to leave open the possibility that there might be instances where they want to do that, if they want to deviate, if they want to require more.
I will admit to preferring the need not version of that language myself, but let me call on Ron Levin, please.
Yeah, I was going to raise the question of whether to undo Allison's change, because I think John wrote it initially to bring out the idea that different courts do it different ways, and that shade of meaning gets lost in her version. What I had thought of saying was allow that matter to be governed by rules in which the judicial review is sought. The word applicable, I think, would be superfluous under that approach.
I'm sorry, so I'm not entirely clear on what language on how you would phrase it differently relative to what's on the slide at the moment.
So what I would do is to strike the word applicable and court, and add before the period of the court in which judicial review is sought.
I see, just undoing Allison's change.
Correct. But also taking out applicable, because people are only going to look at the ones that are applicable.
Sure. I don't know, Allison, how you feel about that, as opposed to just striking your proposed change, as opposed to, whether you're convinced or whether you particularly like still applicable court rules as a possibility.
I'm not seeing the difference in substance. It just seems to me like using a lot of words to say something you could use just a couple words to say, but I think they say the same thing substantively. It sounds like Ron thinks they say something different, and not understanding the difference, I guess I have a preference for mine. If there is a difference, I can't, yeah.
I was really borrowing from John's idea, but I thought his idea was that different courts do it differently. And so if you say applicable rules, you're obscuring the fact that it's going to vary with the particular court. Since Congress isn't actually going to legislate, rather it's going to let whatever court rules apply in the respective.
So, I mean, to me, the applicable court rules are the rules of the court in which review is sought. But again, I'm not trying to say something substantively different. I just thought it was an easier way to say it. So if, you know, the committee prefers more words to fewer, I don't object.
I will concede that I find the longer version clearer. But I see hands from John Duffy and John Siegel. So please go ahead, John Duffy.
I was just going to make the point that you just made, which is, I think, applicable court rules might sound like there's one body of court rules, which there isn't. Rules of the court in which judicial review is sought, it seems to me, is more precise and alerts the reader that there could be different court rules for different courts. And indeed, there's local rules and all kinds of other variations. That's all.
John Siegel?
On this point, I think I agree with Kristen and John Duffy, although it's not a big deal. I wanted to go back to Don Elliott's suggestion about how it would be more polite to say Congress should not routinely or normally specify this. And I would resist that a little politely, of course. But my comment on that would be, again, having read through all these statutes, I can tell you it is already quite rare for Congress to specify the required content of the petition for review. So it's already true that Congress does not routinely do this. Indeed, the only statutes I can immediately recall where Congress did do this are the Hobbs Act, which has been held to have been superseded by the Federal Rules of Appellate Procedure in accordance with the Rules Enabling Act, and the main statute governing review of FCC orders, where it's not clear. I mean, logically, that should equally be superseded, but many people in the FCC community still take the trouble to include what the statute says they're supposed to include, I suppose, out of lawyerly caution. So anyway, my point is, if we just say Congress should not normally do this, we're not really recommending any change. So I think I would prefer to keep that out. I mean, I don't think this requires any change on the screen at the moment. I'm just making my comment on that.
I will make the observation that, I take your point, John, about routinely or normally. I think the concern I had with the word should not is, at least, not that I have a lot of experience in this, but telling Congress not to do things, I think, I think if we use language of suggestion rather than should not, that's why I like need not, but I also don't feel super strongly about it. Don Elliott, please go ahead.
I like need not. I think that's I think normally when they do it because they don't realize that it would otherwise be governed by the rules of court. And I just think need not is a little politer, and it leaves open the possibility that in some case they may decide that they want to have greater pleading requirements. So I support need not as a friendly amendment.
Bill Funk?
I agree with the need not, but the comment I wanted to make was to substitute for but should instead allow that matter to be governed by, put in because that matter would be governed by. Because that matter would be governed by. This explains why Congress need not do it, and without putting a should suggestion that they should do something or not.
John Siegel, do you find those changes acceptable?
They're fine, yes. I mean, I guess I would just point out to say Congress need not do this, to me, is not exactly a recommendation. I mean, if we're making a recommendation, to me, that takes the form Congress should do something. So, if that's what the committee wanted, I'm not, as Duffy says on some of these things, Professor Duffy says, I'm not going to go to the wall on this, but it just does not strike me as being in the category of recommendation. But if the committee, would like to express this more politely and thinks that need not accomplishes that, it's okay.
Bill, I'm not sure if your hand is up because you just didn't put it down or if you had something you wanted to add. Okay, it looks like it just went down. I now see a bunch of hands. John and then Allison. John Duffy and then Allison.
Well, I was just going to say then that the Bill Funk suggestion I would agree with if we go to the need not version, because the should and should was designed to be parallel. The should and not and then but should, that was designed to parallel the original language. If you do switch to need not, then I agree with Bill Funk's suggestion.
I agree from a parallelism perspective with respect to the language. Allison, please go ahead.
So I was going to suggest that a compromise would be to start with need not, but then keep the should instead at the second part, because it does make the first part less of a recommendation. It does sort of raise John's concern, but then the second half keeps the stronger language. So although it's not parallel, it serves the purpose of the original comment. I can't remember who made it, who wanted to be more polite or tone down the way it was written, but also would maintain through the second half John's concern that we're not actually doing anything if we don't say should. So yeah, it wouldn't be parallel, but it would be a little more polite, but also get the point of still include a should in there somewhere. It's just I don't really care. It's just a sort of attempted compromise.
Bill Funk, please go ahead.
One of the reasons to take out should instead allow is the suggestion that Congress should actually pass a law saying this shall be governed by the applicable court rules. And I don't think we want to suggest that Congress amend the APA to say anything with regard to this. That's why, because the matter would be governed by, explains why they should not or need not require the content of the petition for review. So despite parallelism, I would suggest that because the matter would be governed by, should be adopted in either case.
That makes sense. I rescind my comment. I think that you convinced me.
John Siegel.
A different possible compromise. How about Congress should be aware that it need not? And then Bill Funk's because. So that way we
Sure.
put in
That
there.
makes it polite but less forceful. I think at this point, again, this is one of those, to the extent that we're going to have a version of this on April 22nd that includes a preamble and is arranged more in the manner of our traditional recommendations. I think at this point, we've got a lot to go on, and John's got the sense of the committee. And so perhaps we can move on to item 6, if everyone is in agreement with that. Bill Funk, go ahead, please.
John Duffy had a additional recommendation for this one. And I wanted to support that, particularly because I have to leave shortly for another appointment. But he has something to insert. A party seeking judicial review may initiate review by filing either a document complying with the requirements of any special statute authorizing review or a document complying with the applicable rules of court. And I would suggest that that's, I think that the phrasing of it, I think where the either goes is a different question, but the idea behind that, I think, is a good one.
John Duffy, go ahead, please.
I'll just explain what's the motivation behind this. The motivation is, of course, not in conflict with the first paragraph that we've just wordsmithed, but this would be what to do with legacy statutes like the Hobbs Act that already do have a specification. And so right now it's despite our recommendation that Congress should be aware and should, let normal things govern, there are a number of statutes out there that don't operate that way. And therefore, this would be a suggestion that Congress should pass some sort of legislation saying that it's optional, either one will suffice. I want to make clear that I'm not necessarily talking about the issue of where this should go, whether it should be in the Hobbs Act, whether it should be in the APA. I'm not addressing that issue. This was just an issue that for those legacy statutes, this kind of language would prevent somebody who makes the wrong choice from being sandbagged by the particular statute. That's all.
So does this sentence, John, need to begin with the phrase Congress should provide that?
Yeah, I suppose you're right. This is more in the line of a legislative recommendation. So Congress should provide that. Yeah.
Okay. Whether it ends up here or somewhere else, again, the suggestion was made. I don't know that we didn't particularly discuss it, although I think it's worth at least considering, to the extent that some of these recommendations are specifically calling upon Congress to do certain things, and others of them are more in the vein of advisory to Congress more generally. How we organize them when we finally come up with actual recommendations and a preamble, there need to be some consideration about putting these two items in different parts. But I will leave that to the people who put together the eventual document. John Siegel, go ahead, please.
I'm sorry, Kristen, I know you want to move on, but a comment on
Sure.
Professor Duffy's suggestion. I have no objection to this suggestion, but I do just want to point out the Hobbs Act specifically, as I mentioned earlier, has been held to have been superseded by Federal Rule 15, Federal Rule of Appellate Procedure 15, in accordance with the operation of the Rules Enabling Act 28 U.S. Code 2072, which says that rules adopted pursuant to the act supersede earlier statutes. So the Hobbs Act has been specifically held to have been thus superseded, and logically, all other requirements of a similar nature that existed at the time Federal Appellate Rule 15 was adopted should also have been superseded. So I think, as far as I know, and again, this is from having read through all the statutes, I think the set of statutes to which this new suggestion by Professor Duffy would actually apply might currently be an empty set. And therefore, as long as Congress conforms with our recommendation prospectively, there might be nothing for this to apply to, which is not to say that it's not a good idea, but it might actually not apply to anything.
Professor Duffy, do you have thoughts?
Well, I guess I'm wondering if the courts, what happens today if somebody mistakenly files a document that complies with the Hobbs Act but does not comply with court rules?
I'm not sure that could happen because I'd have to think about that one. I think
Right.
the Hobbs Act provides for everything that the court rules would require and more.
Maybe we should talk about that offline, maybe, and let the meeting go forward.
Okay.
Sure. That could be something that can be resolved between now and the 22nd. Moving on to item 6, please. If we could scroll down on the document. And I can't tell, does it go on to 2 pages? There we go. Okay, thank you. Okay, so John Siegel, can you help clarify the point of the struck through text of 2112?
Sure. I mean, this one, we have, I provided very specific text in this one. So this one may be easier than some of the others where I wasn't as specific as to the text. So the point of this one is that the prior ACUS solution to the race to the courthouse problem, I mean, first of all, what is the race to the courthouse problem? The race to the courthouse problem was occasioned by statutes that said where there is a single agency action that is the subject of multiple petitions for judicial review filed in different courts, the rule used to be whichever was the first such petition filed took priority. So that led to unseemly races to the courthouse and to some rather ridiculous court decisions in which courts had to determine which petition for review was filed a few minutes, or in some cases only a few seconds, before some other petition for review. And it had the effect of favoring wealthy parties that could afford to have someone stationed in the court clerk's office just waiting for the instant the agency action occurred so they could file a petition for review. So the ACUS solution was to say, where there are multiple such petitions within 10 days after the agency action, there should be a lottery as to which court gets to hear the petition for review. But the particular way it was phrased, as you can see, was it said where the agency receives multiple petitions from the persons instituting the proceedings. So that gives rise to the following question. What if the agency receives one petition from a person instituting a petition for judicial review, and it receives another petition filed in a different court, but it receives that one from the clerk of the court? Because many statutes provide that when you file a petition for review, the clerk of the court shall serve it on the agency. You don't have to do it. So unless you happen to know that serving it yourself will advantage you in the race to the courthouse lottery, you might not do it. And then if this statute is taken literally, only those parties who not only filed a petition for review, but who served it on the agency, rather than letting the clerk of the court serve it on the agency, would get to participate in the race to the courthouse lottery. And if you ask, well, could courts take this that literally? The answer is they already have. There are specific cases saying, you know, we're all textualists now, and this language should be taken literally. And if the agency gets the petition for review from the clerk of the court, that does not count. So by striking through what I have proposed to strike through here, it would not matter whether the agency receives the petition for review from the party filing it or from the clerk of the court. Everyone would get to participate in the lottery.
Alan Morrison.
I just want the record to reflect that it's not the fault of the Administrative Conference of the United States that this arose. As John's report shows, we did it properly, and it is not our fault, our being, including me, because I was on I was a fellow at the time. So I just want the record to be clear on that this is not our fault.
I don't think anybody's blaming you, Alan. Okay, so let's see here. Does anybody have any thoughts or concerns about this particular recommendation? Okay, I'm seeing thumbs up at this point. So let's move on to recommendation number 7, please. Great, thank you. Okay. And here again, so with apologies, Bobby, I can't read the comment from John Duffy in the bubble. Okay, so, and it's a lengthy one. So how about I call on John to help us out here?
Sure. So the well, I guess I have 2 comments here, and I guess in John's original opening remarks, he said that there should be, that he was open to the idea of having something that nailed down the reasonable promptness standard a little bit more carefully, which I think that that would be that's part of what I want to do here, I suppose. So I wondered if, but I guess he's leaving it as reasonable promptness here. I wondered why he left it that way. Is that, John, is that why do that?
I just wanted, I'm sorry. That was not in any way intended as a rejection of the suggestion. I just wanted to leave it to the committee to pick whatever particular language it included instead of reasonable promptness.
Okay. So we might move to a number of days. Do you want to take that issue first, Kristen? That seems like a
Sure.
more,
Why don't we take that issue first? I will admit for myself, I am uncomfortable, I think, with specifying I have no objection to telling Congress to specify a particular number of days. I'm personally a little bit uncomfortable coming up with the specific number of days that I think they ought to adopt. But I don't know how other people might feel about that. And I'm not seeing any hands. Bill Funk, go ahead, please.
Well, we can be very polite. We could say that we could suggest they provide for a specific date that's reasonably prompt, perhaps 7 days. In other words, here's a suggestion. You can take it or leave it. We're not, we think it's a good number of days, but you can change it if you think it's a different number would be appropriate, but we think a number would be appropriate.
So perhaps instead of saying reasonable promptness, say something like the document is served on an agency within a specified number of days. Well, such as 7, but that seems very clunky. Bill, you want to try to help me out with the wordsmithing?
I was going to say, perhaps 7 days. I mean, I don't know if it's clumsy, but it's.
you could say a reasonable but specific number of days, such as 7 or 14.
Yeah, fine.
Yeah, change perhaps to such as 7 or 14 days.
I'd leave it at 7. I mean,
Fine.
14, 2 full weeks is actually a long time.
Yeah.
Okay, now with that wordsmithing having been done, we've got several hands up. So, Bill, I'm not sure if your hand up is up from before. Okay, then how about Alan Morrison, please?
I just want to point out, and I don't necessarily urge it, but Rule 4M of the Federal Rules of Civil Procedure requires complaints to be served within 90 days of their filing. I don't urge that. This is a statute which Congress said simultaneously, but I just want people to know that that's there in case somebody asks what other possibilities there are. And that might be included in the preamble, just so everybody knows that we know that, which we now do.
Okay, that's a good point. Bobby, perhaps you can note as a bubble comment to recognize the 90-day rule from the Rules of Civil Procedure in the preamble as a possible suggestion. John Siegel, let me call on you, please.
Thank you, Kristen. If we're going to mention a specific number of days, I would just push for 14 rather than 7 for the following reason. This is one of those instances, it's similar to recommendation number 3 in this regard, where, I do not have any actual record of any case in which the current situation is a problem. All these statutes that say serve the agency simultaneously, I do not have even one case that got thrown out because of failure to serve simultaneously. Whereas if we say you must serve within 7 days and someone serves within 8 days, there could be a problem. So this whole thing, this whole suggestion is included only because I dreamed up the possibility that a government lawyer might say, oh, ho, you didn't serve simultaneously. It was really a few days later. So I would hate to change it to something that makes it more difficult. And it seems to me 7 days could make it more difficult, whereas 14 seems pretty safe to me.
Or we could just go back to reasonable promptness, which is, unsatisfyingly standard-like. Don Elliott, go ahead, please.
Well, John and I are thinking along the same lines, but maybe he's reading my mind. But I'm concerned about setting a specific time limit. And a very important judicial review is canceled because the service on the agency was late, even in a situation where the agency already knew that the case was being filed. So if we're going to set a specific limit, I think we need to soften it somehow so we don't create a problem of where things are dismissed. I think the other thing is, Rule 4 generally contemplates of the Federal Rules of Civil Procedure generally contemplates a situation where you can serve a complaint in the district court by mail if that's permitted under the rules of the state. So I think if we're going to have a specific limit, we should probably also address how service can be made, and can service be made. Or we could say it should provide service within a specified period of time. I prefer 14 as opposed to 7. But I think we might want to add the notion unless the agency already has actual notice or something like that. I'm just concerned that if this is a non-problem, we may be making things worse by setting a mandatory limit.
John Duffy?
So that might, Don Elliott's comments might actually lead into my other suggestions. The first of which is, why are we, keeping a service requirement? The Hobbs Act actually requires the clerk of court to just serve the government. So it's done automatically. And, to me, that just seems like a super reasonable thing. And that really would address Don's, comment that forget about reasonable or 7 days or 14 days. Like, the agency might find out about this stuff, and the Hobbs Act actually gives this really reasonable procedure. I think the only thing that's a little unreasonable is it says that the clerk of the court should mail it, meaning mail the US mails, which of course I think these days is archaic. But the clerk of court can just simply, forward it onto the agency, serve it electronically, serve it to the Department of Justice electronically. It seems like, given that we have a precedent for that, why don't we fully endorse that that's the more forward-looking approach to this?
John Siegel, do you have a reaction to that suggestion?
I would say I agree with that.
So what would that mean that we would do with our recommendation linguistically? While you're thinking about that, Andy Vollmer has his hand up. So let me call on Andy Vollmer, and then we'll see if there's some language here. Andy, do you want to weigh in on this point?
Thanks. My worry is that service by the clerk of court is, to me, an extremely complicating method. And so I understand it's in current statute, which has limited applicability, but I would hate to compound that. I think, and this whole issue to me concerns the most efficient, cost-effective method of service of the initiating document. And my reaction, after having litigated for decades in one way or another, is that the plaintiff, or the equivalent to the plaintiff, knows that it must serve the document on the opposing party and has the obligation to do that. And I think we ought to leave the obligation on the private party to get the service to the agency. And relying on the clerk of court just seems to present potential for mistakes and inefficiency and overlooking things. I just don't want to rely on the clerk of court. I want to rely on the private party. They know they've got to do it. They know they've got to do it right. And we have the further complication that some statutes require service on the Department of Justice. To me, I don't like that either. I understand, I think the general rule for this whole project is we're not looking at trying to amend underlying substantive statutes that Congress has made certain choices and we're just living with that. So, and that's a perfectly good approach. I don't have a problem with that. But anyway, I really don't like the status of the service complications, and I resist the idea that we ought to perpetuate or expand the clerk of the court thing. I would like to simplify. So my goal is simplify, reduce costs, put the burden on the private party.
So I did see, I will record for the record a thumbs up from Dick Pierce in response to that. I've got John Duffy next in my queue, although I'm not sure if that's a new hand or an old hand. It's an old hand. So Alan Morrison, please.
Oh, I just want to inform Andy that the new rules on Social Security for review in the district court provide expressly that the clerk of the court shall notify the agency of the filing of the petition. They deliberately take it off the Social Security recipient having to do that. And the Social Security Administration was in favor of that, as I recall, during the course. I certainly didn't raise any objection to it. I don't understand that we're going to try to, I mean, my understanding, and John Siegel, correct me if I'm wrong on this, some statutes provide one way, some provide another way, and some don't provide anything at all. And we're not, at this point, I think, suggesting that we go through all the statutes and ask Congress to amend all of them. And so I think we ought to be focusing on, we're dealing with a simultaneous problem here. And the only thing we're doing is trying to make a recommendation to deal with those few statutes that have the word simultaneous in it. And therefore, I think that we ought to confine our discussion to that rather than trying to change the method of service or anything like that, either one way or the other.
It is a really interesting point about different litigants being in different postures. I can see a very big difference between a Social Security disability recipient versus, a large corporation that's a regulated party and has lots of high-powered attorneys representing them. Other thoughts on this one? I don't know that we've necessarily reached a conclusion about which direction to go. John Duffy, go ahead, please.
So I kind of agree that the simultaneous issue is a separate issue. I guess that I was just suggesting that we should be more ambitious with this project and at least consider the possibility that these service requirements are archaic and are not really necessary in an era of rapid communications, particularly when the party is ultimately the government, and you are filing, the formal complaint, the formal petition for review with a component of the government. This is, of course, Article 3 component rather than Article 2 component. But nonetheless, I think the Hobbs Act is a pretty good model. And as far as Andy Vollmer's point, the Hobbs Act is pretty general. I mean, it applies to like FCC rulemakings and things like that. So it governs it's not applicable just to like Social Security things where you might think the litigants are, sort of unsophisticated. It governs some pretty sophisticated proceedings. So I don't know, I think we should be a little more, I mean, I like the simultaneous thing, we should have that, right? But we might consider suggesting that Congress at least consider the possibility of following the Hobbs Act.
So Bobby, it might be helpful if you move that comment box over to the right just a little bit so we can actually see what's also in the document itself. Thank you. Let me call then on John Siegel, please.
Just following up on what Professor Duffy just said and further responding to Andy Vollmer, I wanted to point out Federal Rule of Appellate Procedure 15 already says, this is the federal appellate rule that governs judicial review of agency action. It says the circuit clerk must serve a copy of the petition for review ... on each respondent, although it does add unless a different manner of service is prescribed by statute. So the point I'm trying to make by bringing that up is it's already contemplated in the Federal Rules of Appellate Procedure that, unless the statute says something else, that's how service will be made. It will be made by the court clerk. So it isn't that radical to suggest it. Now, I don't think there's any comparable rule in the Federal Rules of Civil Procedure. So for cases that start in district court, there isn't this same presumption that the court clerk will serve process. But again, just having been through all these statutes, I can tell you, there are a lot of statutes that say the party is supposed to serve process. There are a lot of statutes that say the court clerk is supposed to serve process. So it's not a radical idea that the court clerk would do it. And I just wanted to make that point.
So I will say it does strike me, at least at this point, though, that we have two very different, and correct me if I'm wrong, because I may be not following this properly, but it does seem to me that we have two very different proposals here. One being to suggest a particular number of days, and we had objections raised to that idea, at which point then we moved to the clerk of court making the recommendation, or excuse me, making the service. And these do not strike me as, I don't know that you can reconcile the two so much as you have to pick one, which raises at least a question to me about whether this is a choice to be made as part of this set of recommendations, or whether we should go, have another project on this or go a different direction. I just don't know what to do with this at this point, is I guess my point. And I have 3 hands in the queue, so I'm going to assume they all have ideas. So Don Elliott, let me start with you, please.
Well, I wonder whether or not we should just leave this to the court and to the rules of court. I do think that the concept of service is a somewhat antiquated concept and doesn't really belong here. It simply increases costs. As a practical matter, in my experience, having litigated cases for 4 decades, as a practical matter, you send a copy to the opposing party by email, and paying for formal service, it just strikes me as antiquated. Plus, I think if Congress does legislate about this, it may last for the next 50 years. Plus, I think we in earlier points made I thought a very good recommendation that we defer to the process of the court. So I don't know why we should have specific recommendations about how notice is given to agencies in statute. I think we should again defer to the evolving rules of the court in question. All of the courts in question are going to address, either through the federal rules of appellate procedure or through local rules, how the opposing party gets notice. So I think that's good enough, and I would be opposed to making a recommendation about this at all.
So is that a proposal just to drop this item 7 entirely?
Yes.
Okay. Ron Levin.
I just had one question, which is whether in this situation in which the party initiates review and is expected to serve documents simultaneously on the agency, will it commonly or even sometimes also, will there also be other respondents who also need to be served? If that is the case, then I think you're increasing the burden on the clerk more than you really want to do, and it would typically rest with the party. My own sense about this is you don't need to say it has to be prompt. I think that could be inferred if you just said it should be served within a specified number of days. I think they'd figure out it's not going to be 90, given the nature of what we're talking about. And so I think you could just simplify it by getting rid of simultaneously and saying specify the number of days it is, and they're going to come up with a time they think is reasonable.
Recognizing we only have 3 minutes left, I have John Duffy, Alan Morrison, and Don Elliott in the queue. Let's go with John Duffy first, please.
Okay, well, I do think quickly the clarifying the simultaneous language is separate and could be, listed as a separate issue. But I think we should have a more ambitious question, a more ambitious issue about whether there should be service retained for the government parties. And the reason for that is because John's work, his larger work, did note that the problem is that some parties fail to serve. the federal government, either correctly or ever. And if we're worried about failure of service, then the Hobbs Act provides the way. So the way I envision it is you could have recommendation new 7 that says the Congress should consider eliminating or following the pattern of the Hobbs Act. And then recommendation 8 would be where Congress wants to keep this simultaneous requirement, it has a specified number of days.
Somebody dropped out of the queue, but and I did not keep track in that regard. But Alan Morrison, I have your hand up as next in the queue.
I think we need to keep the problem part about simultaneous, and I'm not in favor of going anything further as John Duffy would do it. It seems to me this report does not give us the basis, and there's too much confusion. I mean, too much uncertainty about what we would be doing and why. And so I would leave that for another project or another day. And John didn't identify it as a particular problem. So whatever the theoretical problem may be, I don't think we have a basis for even telling Congress it should consider doing something that we don't quite know what we're going to consider them to do.
So at this point, we've got 3 different recommendations. We've got setting a particular time period. We've got substituting the Hobbs Act approach, and we have deleting item 7 altogether. And with that, we are pretty much out of time. So I think what we're going to have to do at this point is, I think, leave this perhaps to be discussed offline and resolved between now and the 22nd. And, to the extent that this is just an intermediate stage, we will see what John and the staff come back with for purposes of the recommendations to be considered at our meeting on the 22nd. We also still do have other points to consider. We did have several comments that were submitted that ought to be considered at some point in time, but at this point will have to be left until our next meeting, with apologies for the people who raised them. And I think at this point, I hope that we will have such good attendance and participation at the April 22nd meeting. That meeting, I believe, is scheduled for April 22nd, beginning at 11 a.m. Eastern time again. So more details will certainly follow, but please be sure to put that on your calendars if you have not already done so. And with that, unless I see any objections, I think we will adjourn for the day. I think that's all I have to do at this point.
Thank you, Kristen. And thank you everyone for attending. We appreciate it. Hope to see you next time.
Great. Thank you, everybody.
Thanks, Kristen, for running the meeting so well.
Thanks, John. Appreciate it.